Good morning, sir. Myself, Harshdeep Ananda Deshmukh. My roll number is 144, and today I am going to present the PPT of sources of public international law. The introduction of notion. The term sources of law may mean different things. It may refer to either historical, ethical, social, or other basis for a legal rule, or it may refer to legal rules. As such, the notion will be used here in the latter sense. Sources of international law: treaties and conventions, nuclear test ban treaty, international customs, prohibition of crimes against humanity, general principles of law, lex specialist, derogate legi general, subsidiary sources of judicial decisions and legal publications, ICJ's cases, Brownlie textbook on principles of public international law, yearbook of international law. Hierarchy of sources of international law. Primary sources treating customary rules, unilateral acts, general principles. Secondary sources binding decisions of international organizations, judicial decisions based on principle of equity. Subsidiary sources other judicial decisions doctrine. There are treaties. Introduction: the Vienna Convention of the Law Treaties 1969, called as VCLT, was negotiated during the UN Conference on the Law of Treaties at Vienna in 1968 and 1969. It was opened for signature on 23rd of April 1969 and entered into force on 27th of February 1980. The law of treaties is a body of rules which provides a definition of a treaty and deals with matters relating to the conclusion, entry into force, application, validity, amendment, modification, interpretation, suspension, and a termination of a treaty. It can be said that the law of treaties plays in international law a role similar to that played by the law of contract in municipal law. International custom. Introduction. Article 38 1 Section B of the ICJ statute defines international custom as evidence of a general practice accepted as law. A customary rule requires the presence of two elements: an objective element, a relatively uniform and constant state practice, and a psychological element, the subjective conviction of a state that it is legally bound to behave in a particular way in respect of a particular type of situation. This is referred to as a opinio juris sive necessities. Custom may be either general or regional. General customs are binding upon the international community as a whole. Local and regional customs apply to groups of states or just two states in their relation inter. Local customs may supplement or derogate from general customary international law. General principles of international law. Article 38, Section C of State of the ICJ refers to the general principles of law recognized by civilized nations. These principles are common to several national legal systems, and they are appropriate from the point of view of international law. Some examples: the principle that a breach of an obligation enters an obligation to make reparation, the principle of res judicata, the principle of estoppel, the principle of admissibility of circumstantial evidence. Now, judicial decisions. Article 38 1D of the statute of the ICJ directs the court to apply judicial decisions as subsidiary means for the determination of rules of law. Judicial decisions are not therefore a formal source of law. However, they clarify the existing law on the topic and may, in some circumstances, create a new principle in international law. They can also be considered evidence of state practice. Precedent has no binding authority in international law. Declarations: an uncertain source. Declarations are of various kinds. They may be adopted by a group of states or by a statute or by an IGO to express their intention or views on a particular point. Whether a declaration produces legal effects depends on the context in which it has been made. And in international law, some declarations produce legal effects. For example, when a state issues a protest objecting to an act or action carried out by another state, or recognize a particular situation or renounce a right. And some are sources of obligation. For example, when a state promises to do something or to abstain from doing something. Thank you.